everybody. Welcome back. Attorney Steve Vondran here, just having a little fun here on my Saturday edition of Litigation Whiteboard. Okay, hope you guys are all doing great today, relaxing a little bit, enjoying your Saturday. But I had some questions lately popping up. People are talking about the big tech takeover in Section 230. Section 230 of the Communications Decency Act. You might hear this a lot. Somebody wanted to know what exactly is it? Can you just give me a quick overview? Okay, that's what we're here for. But without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, let's come up here. We are talking today about internet defamation. Okay, a lot of people are talking about this. Okay, in particular, here's my companies. Here's all my companies. I'll talk about that in a second. You got your user over here. Here's your internet user. He or she's posting things on, or depending on their gender, posting things on Twitter, Facebook, Craigslist, Yelp, YouTube, whatever. These are posters, and these people say, well, I have my freedom of speech. I can say whatever I want. Well, there's limits to what you can say. You can't defame somebody, for example. So say this person here, let's just take a phrase. Somebody says he posts on Twitter or Facebook, he's a rapist. He's a rapist. And somebody would say, well, that's defamatory. You're defaming me. I'm not a rapist. I've never raped anyone. Dude, there's no crimes. What are you talking about? So if you have something that could be considered defamation, okay, a false statement of fact concerning somebody else, it tends to injure them in their reputation, their business, their profession, their name, okay? So the typical rule is if somebody defames you, you just go right after them. You go right after them. But what people want to be able to do is they want to go after these guys. These people don't always have a lot of money, okay, number one. So they want to go after the big company, the hosting platform, okay? I got some companies up here, your Twitters, your Facebooks, your AOL, where they host all the content, okay? They run and host everything. Amazon, Google, eBay, Yelp, Craigslist, these kinds of companies that host pages where people can upload user-generated content, UGC, okay? They can upload that. So the question is, can you hold what we call the Interactive Computer Service Company liable? Can you hold them liable for the acts of this person because it ends up on their platform, okay? And the general rule is no. Why is that? And this is not legal advice. It's general legal information only. So, you know, there's nuances and exceptions and new cases and all kinds of things. All right. So 47 U.S. 230 says it's under the Communication Decency Act. This is what we call the 26 words that created the internet. The 26 words that created the internet, which allows these companies to post and provide these platforms for people like you, me, to come post, share information, share pictures, do all these kinds of things, okay? So in general, this section, the 26 words that created the internet, say they're not liable, okay? This is the general rule, not liable for what other people do, okay? Now, let me read this to you here, just so you can say, Attorney Steve actually read me those magic 26 words. Wasn't that nice of him? So I pulled it down here off my, what did I have here? My, Law at Cornell, very good site, Law at Cornell. It's protection for Good Samaritan blocking and screening of offensive material. Here's what it says. More specifically, this is section 230 C1. These are the two issues usually at issue C1 and C2. Okay, C1, C2. I'll talk about that in a second. So C1, what it says is the 26 words, no provider or user of an interactive computer service shall be treated as the publisher or the speaker. So you don't want to be the publisher or the speaker of any information provided by another information content provider. So somebody else that's providing content. So the general rules is this is an affirmative defense that you can raise if somebody you have an interactive computer service. You're one of these types of companies, and there's hundreds and hundreds and hundreds of different companies like this. Interactive computer service, if you fit that definition. I'm not going to go into the law right now. I think it's on this page, but I'm not going to go into that right now. But if you fit the definition, you're one of these companies, the general rule is immune from liability. Immune. Or you call it a safe harbor, whatever you want to call it. Bottom line is you're going to be raising this as an affirmative defense, okay? We got it right there. Raise it as an affirmative defense if you get sued for something one of these people do over here, okay? Now, let's get rid of that. Okay, what else do we have here? Now, there is a rule that says if it's intellectual property that's being posted, if this person is posting copyrighted content, let's say a movie, a video, something like that, then they need to be careful, and upon notice, upon usually what we call a DMC takedown notice, this will usually be taken down by the companies. That's why you see takedowns, okay? So that's what I call an IP carve-out for intellectual property. Now, where did this all come from? I found this really interesting as I was researching it. How many of you remember the movie, The Wolf of Wall Street? Did you see that with Leonardo DiCaprio? I saw it was a hilarious movie. But as you know, that was about this stock company that was essentially eventually shut down and, you know, convicted and whatever else happened. Okay. But point is, it was the Stratten-Oakmont. You guys remember that Stratten-Oakmont? All right. So, but this was the case, and what happened is the Stratten-Oakmont, the financial firm, they sued Prodigy because somebody had defamed them, the company. They had actually said that Stratten-Oakmont was a fraud. Can you believe it? But they actually sued. So they sued. They had this person to sue, but more importantly, they wanted to go after Prodigy. Let's put them Prodigy. And so the lawsuit was filed, and Stratten-Oakmont won. Stratten-Oakmont won. And so after that, a couple years later, I think this was 1996, if I recall, a couple years after this case, which I think was 94, somebody says, we better pass a Communication Decency Act or everybody's going to get their pantsuit off here. Okay? So Section 230 was passed, the 26 words that created the internet. Now you can host these services without worrying about being sued every time somebody does something different. Okay, moving on though. Okay, now we're getting into our nowadays. Now we have basically the president is very upset with the services, and he had an executive order. You can go look it up if you want. He had an executive order on wanting to look into this, clamp down, wanting the FTC and the FCC to look into the actions of service providers, these computer services, to see if they're engaged in some of these extra activities, which could make you a speaker. You see, follow me here. Could make you a speaker and a publisher. Now, what kind of things are those? Well, here's some of the things that they're talking about with big tech, as they call it. Deplatforming people, silencing people, putting fact checks, saying that this is disputed. Okay, that's kind of something that you may hear a magazine do in an editorial. This is disputed. This is what's going on. So they're not, what the issue is with the 230 and nowadays what's going on, they're doing these other things aside from just sitting here and allowing people to post. They're actively getting involved in other things, what Trump would say, one-sided political. They're basically making everything one-sided, their view only, blocking what they don't like. It's coming up with a fact check, which tells people, hey, what you just read. They'll put a fact check. He's talking about fake trends. Hey, this is trending when it's really not trending. These are not my points of view. This is what the president's bringing up. So this is why we have all these issues now, why Trump wants FCC, FTC to look into false and misleading practices, being the fact that maybe some of these things, by doing them, are giving a false impression. But a lot of people don't think this is going anywhere. I tend to think it's probably not going anywhere. But we'll see. We'll see. Maybe there needs to be some tweaks in here, maybe not. So that covers that. These are the types of things: fact check, misleading labels. You're saying, you ever seen the one that says, your post is misleading as it leaves everything out? And I go, what the heck? I mean, do I have to write a 10-page dissertation complete with cites just to pass the misleading? If you don't have the full context, something's always misleading. So that's something that they're also talking about. Disputed. Are they becoming a publisher where they would lose their liability? Okay, so that's the issue. That's the issue. Now, I also want you to point out, sometimes you over here as the user, you'll be like, hey, I got the First Amendment. I got the First Amendment. I can say whatever I want. What's the problem? Well, these are private platforms, okay? So most of these, it means they don't get government money. They're just like a private restaurant. They can do what they want. It's kind of like a club, or it's a thing. You don't have to join. You don't have to be on these platforms. There's other places you can go if you don't like it. And I think that's really the way these companies look at it, is there's, billions of people in the world. Respectfully, we don't really need you. We'd like to have you. So they're private. So if you get deplatformed or blocked or disputed right now with the liabilities, and maybe somebody's calling you a rapist, you still got to go back at this person if you can find them. So that's what the Section 230 liability is all about. And I just wanted to give you all a view of that. That's what's going on. Now over here, one more thing I want to point out before I wrap this up is terms of service, okay? Again, these communities, let's call them online communities, are able, and they do have terms of service. They have repeat offender violations, things if you keep doing them, they have to take you down. But there is a list of what we call Good Samaritan, Good Sam, good things they can do without being deemed publishers and everything else. And it's a form of editing, but they can take down certain things. I'm going to read this for you real quick on my little handy thing here. I got these new magnets that are pretty cool, so I'm doing that. It says here, no provider or user of an interactive computer service shall be held liable on the count of, let's take a look at these over here, any action voluntarily taken in good faith, lots of dispute, what's good faith here, a material, one more time, any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be, here's the words, obscene, lewd, lascivious, filthy, excessively violent, harassing, or, here's the big one, I love this big open, or otherwise objectionable. And this is where I think you get your hate speech, and then people interpreting what hate speech is. And again, you say, well, I got a First Amendment. What's going on here? I can say whatever I want. It's not against the law, hate speech. Well, this is a private platform. So you get deplatformed, realize if they're in good faith following their terms, you're going to have a hard time making some kind of case. So the 230 liability, it's important to know. You now know more than most people know, probably more than most of the media knows, more than most scholars know, more than most lawyers know. And let's just leave it with this. Give me a second here, would you? Let's just leave it with this. All right? Got my big Post-it notes now. Bottom line, truth is a nebulous commodity. I think we all think we know the truth. I think we all think we have all the answers. I think the tech companies think they know everything. The media thinks they know everything. We think we know everything as people. Bottom line is, the truth is a nebulous commodity. Let's get used to these platforms. Let's toughen up a little bit. We're going to have some things that are going to be pulled down, the things you may not like. Realize there's other platforms you can go to. You're not stuck here. By the way, I don't even think you're paying here, are you? You're not paying for like any of this stuff. So anyway, that's my word for the day, my bottom line, my tricks, and one for Chris Gill, my buddy. Taking a little cut here. Have a great Saturday. That's CDA, Communication Decency Act, Section 230. That's what's going on. Are you a publisher, speaker, editor, or are you just a passive website allowing people to post their content? Okay. Have a great day. Attorney Steve out. Make sure you're subscribing. Feel free to share this video on your networks. Go ahead. And if you have any comments, questions, post them down below. We appreciate you watching. Have a great Saturday, okay? See you soon.